Call the third case on this morning's docket, case number 115887, 115888, 115889, State of Kansas v. Jacob McAllister, Jr.
Good morning. My name is Brian Sherwood, Assistant Finney County Attorney. I represent the state. I would respectfully reserve 3 minutes for rebuttal.
3 minutes is granted.
Thank you. Before I get started, I wanted to give a little bit of introduction to the case that is before you on State versus McAllister. This is a petition reviewed by the state of Kansas. Back in 1996, Mr. McAllister went to trial on 3 different cases. One was a drug case, some burglary charges, conspiracy charges, misdemeanor offenses. One other case was 2 counts of aggravated robbery, and the third case was another aggravated robbery. During that time, he went to jury trial, was found guilty on those particular charges, and then at the time, his criminal history included 2 person burglary convictions and 1 count of conspiracy to commit burglary. He had a total of 515 total months for a sentence term, and in May of 2015, the defendant filed a motion to correct an illegal sentence here in Finney County and declaring and asking that his criminal history, that those 2 burglary convictions and the conspiracy to commit burglary should not have been scored as a person felony, but rather as a non-person. The court denied that based upon res judicata and retroactivity issues. It did go to the Kansas Court of Appeals, which they made a final decision in stating a defendant whose sentence is illegal based upon the holdings in State v. Dickey is entitled to receive a corrected sentence at any time, even if those sentences become final prior to the decision in Apprendi v. New Jersey. And that is why we're here today, is because the state is requesting that the Court of Appeals decision be reversed. What is important to this case, in particular, that we have 2 issues that are before the court, but the first issue is obviously that back in 1996 through 1999, Mr. McAllister's cases were final, and Apprendi did not come out until June of year 2000. So now we're here on a collateral review in the terms, or at least in the form of a motion to correct an illegal sentence. And we're here before you asking this court for further clarification in regards to the final decision in Dickey 2. Dickey 2 did make comments in regards to that res judicata and retroactivity were unavailing to that particular case. But what's important about that particular case, why it was unavailing, was Apprendi had already been decided, and decided it was a constitutional criminal rule of procedure that was declared by State v. Gould to apply prospectively. It was obviously a nationwide effect in terms of sentencing schemes and also sentences across the nation. In this particular, when Dickey 2 was handed out, Apprendi was already in existence, and Dickey 2 made the analysis through the use of desk camps as well, the desk camps decision, and before this court, made the decision that they could correct the sentence at any time. The next logical step, I think, for this court to consider is, now that we have an Apprendi issue that has clearly been decided before this court to be applied prospectively, not retroactively, is how does it play into the scheme of things here that we have here for motion to correct a legal sentence?
Is it really an Apprendi issue?
Pardon?
Is it really an Apprendi issue?
I would say it is.
Well, Dickey 2 said it wasn't, right?
I respectfully, I don't know that the court even looked at Gould, decided Gould, even considered Gould. I don't think it was necessarily even argued, or Apprendi was argued. It was unavailing because Apprendi had already existed. The reason why the state thinks that it's still important to this court to consider is because at the time, Apprendi was, the state statutes did not have anything under those sentencing schemes to say that it was illegal, other than the fact that Apprendi was the mechanism or the trigger or the linchpin of the particular case that started that analysis, and it was the precursor for that decision to come forward and to declaring that Dickey's criminal history or the motion to correct an illegal sentence should have been granted. So it has to be the forefront of why everything took place. That was such a monumental decision that in 2000, that was so important for the scheme for this court to consider that became the importance of why Mr. Dickey's sentence was declared illegal. So,
but the opinion itself, if I recall, correct me if I'm wrong, said that the reason Mr. Dickey's sentence was illegal was because it didn't conform to the statutes. And admittedly, there was I think what we called a constitutional overlay to the analysis, but the sentence was not illegal because it was unconstitutional. It was purely as a matter of that it did not conform to the statutory scheme.
I agree, but the only way that we would be able to get there is because Apprendi is the one that set the mechanism or the rule.
How is your client situated any differently with respect to the statutory scheme than Mr. Dickey was?
You're talking about to the state of Kansas?
I'm sorry. Correct. I'm sorry. How is the defendant in this case situated any differently?
Well, his was final before Apprendi. When he was decided, his sentence was in 1996.
I guess my question is, why does that matter if the question before us is whether or not the sentence conforms to the statutes?
Cases dealing with collateral review with a new constitutional procedure rule has been declared to be prospective.
You're just arguing that Dickey 2 is wrong.
I'm sorry?
It sounds like you're just saying Dickey 2 was wrong.
Well,
it was sort of misnaming the analysis as statutory when in fact it was constitutional.
I think the analysis needs to go further, and that's why we're asking for clarification, because I think Apprendi and Gould are cases that are so important that if those didn't exist, those statutes, the sentence would never be illegal. There's a reason why it came back before. It was constantly infirmed because of Apprendi. Apprendi's the case that started everything in this particular case. Back when the sentencing guideline...
Counselor, I think you're talking past each other. The Dickey 2 says, our holding in Dickey 1 demonstrates that the proper classification of a prior crime is exclusively a matter of state statutory law. Then it went on later to say that having clarified the challenge to Dickey's sentences in both Dickey 1 and here are challenges to the statutory propriety of the classification at issue, albeit with a thick constitutional overlay. And so that's what the Court of Appeals panel, and it's important because the Court of Appeals panel relied on that in this case, that we said what we meant, that it's a matter of statutory law, and if it's a matter of statutory law, then 35041 says at any time.
And respectfully, I understand what the Court of Appeals said, but there's also been some other panels that have not interpreted it that way. And they have actually, there's been a conflict down there. There's been some ambiguity in terms of whether or not that Apprendi should be analyzed. The concurring opinion in McAllister.
But the conflict is whether Dickey 2 was correct.
Not
how to interpret Dickey 2, but whether Dickey 2 correctly took into consideration Gould and Connolly.
Or did it go far enough to consider that? Yes. I think Dickey 1, I don't know that the argument was really examined that carefully, but Apprendi was obviously a decision that made its decision to this court, and when they announced that it would be prospective in State versus Gould, and I think this court needs to consider that as well in terms of how it played into this particular statute and how Mr. McAllister somehow was able to make a claim his sentence is illegal even when the sentence was final. as a concurring opinion, McAllister mentioned, the state statute back in 1996, they didn't have, it was not an illegal sentence, it was a legal sentence. The sentence required that you determine the criminal history by the facts, by the preponderance of the evidence, and present it. A lot of the courts back then continue to either consider the journal entries or consider facts to consider whether or not it was a dwelling or not.
Are you saying that the sentence at issue here was not out of conformity with the statutory scheme at the time it was pronounced because the constitutional overlay didn't exist yet?
Correct.
Okay.
So since it didn't exist, there was nothing illegal about that in his file. And then once Apprendi the only reason why he was able to file a motion to correct a legal sentence based upon that constitution was because of Apprendi. And Apprendi being applied to collateral review cases, this one being a different tool that was being used, has been declared to be prospective, not to be retroactive. And I think that needs to be consistent with that decision, because that's what took place here, is that his case was final. And I think the concurring opinion makes some good points that back then there was no elements test in 1996. There wasn't even an elements test before Apprendi even came forward and Descamps decided to take place. Descamps was about Apprendi already existing. Mr. McAllister is about a case where it did not exist and it was already final. And when you talk about those constitutional cases, especially like Teague and Justice Harlan had mentioned, there has to be something that is important to the finality of a case and to the justice system. And that still continues to be an important feature to why a new constitutional rule procedure needs to go forward. This was not declared a watershed rule. It was not declared to be it was a procedural rule that was not a watershed rule that would affect the order of...
So it wasn't a change in the law?
Pardon?
So it wasn't a change in the law?
I do think it was a change in the law.
Change in the law, just not a watershed change.
Correct. I certainly think it was a change in the law because this that relates to the next issue. But in borrowing that from the next issue, this any time language, I heard that in some of the arguments made here. Any time language, like the concurring opinion and mentioned, probably has more to do with the time limitations. It's comparable to the 1507s, 60-1507, the habeas corpus or motion to appeal 14 days. Those are the time limits. They just said we're not going to have any time limits to that. But it doesn't mean that a motion to correct an illegal sentence can be done under any circumstances. And here is where the statute doesn't say under any circumstances. So that's why I make a point that Apprendi is so important and Gould is so important. It's because we weren't going to this court decided that Apprendi-based decisions weren't going to be retroactive, but they were going to be prospective. So in that terms, the reason why it was declared an illegal sentence because you had to use that framework in Apprendi and Descamps. That didn't exist when Mr. McAllister's sentence was available to him in 1996, and there was nothing illegal about that sentence.
Speaking of not existing, I'm going to move you to the second
Sure.
issue. The amendment to 223504-3 did not exist when the Court of Appeals opinion was filed.
I would agree.
What impact does that
Well,
have?
I'm sorry. I think it came back. It came after, because it came after the decision.
McAllister was filed April 28, 2017. The
Right.
amendment to 35043 was effective March 18,
Correct.
approximately 20 days after the filing of this opinion. Does that have any impact on this? And I'm thinking in terms of, at least for that 20 days, this person had a right to have a lesser sentence. So when the statute became effective, it took away his liberty interest that he held at least for a while.
And that going to the next issue, and that's why we're asking, and I know you're going to have these issues on the next one as well, but respectfully, the state in this case is asking that at the very least, it should be applied also retroactively because
Do you have to, do the 2017 amendments have to be applied retroactively?
well,
And one reason why they may not be is the 2017 amendments may have just codified existing law. Is that what happened? Or
well,
was
I do think it was a reaction to the Dickey decisions and the fact that Apprendi was there, and I think the idea was I think the state didn't want people that back in the 90s or earlier that had a criminal history that were sentenced in illegal sentences for them to all of a sudden dangerous criminals to get out.
Well,
And-
back up from all that.
Sure.
In your view, did the 2017 amendments create new law?
Well, it's when we're asking it to be prospective, we think it was a procedural.
I'm not asking about
it create
retroactivity. I'm just
new law?
asking, did it change the law?
I think it tried to reflect the law.
You're saying it tried to codify existing
I think
Supreme
so.
Court case law.
I mean, from my perspective, yes.
In which case, retroactivity is irrelevant.
Well, I think you still have to decide the fact of the change of the law. You still have to look retroactively. It's a retroactive request by it's still. I think you still have to decide whether or not this applies retroactively, and whether it's procedural in nature, and whether this was a change in the law, and whether there's a vested right. I think that's where some of the questions may be. It does all relate back to Apprendi and Gould. If he never had those rights because of Apprendi was only prospective and his case was final, then he shouldn't be allowed either under the current version, which is the amended version, or the one that was before. So,
But the distinction, we've got two back-to-back here.
Sure.
But the distinction in your case is that we have a Court of Appeals decision that vacated this sentence
that's correct.
before the amendment went into effect. Is that to be treated any differently than a case in which the amendment went into effect before the Court of Appeals opinion was filed? The second case, they asked for briefing because the amendment came during the pendency of the appeal to the, but here you had already completed that appeal.
And I do think it still applies to this case, because if you declare that it's retroactive, that you can decide that Apprendi was a change in law and that it was a specific change in law. I know there's cases, I've looked at some other things and what the decision, what is a change in law. Well, this wasn't just mere interpretation or applying some constitutional principle. It was actually a declared change, constitutional change, and it was announced by the United States Supreme Court. So that has to be a monumental change in the law. So yeah, I would say it still applies retroactive to this case as well.
My problem, you have to rely on the fact that this is procedural so that we can apply it retroactively. And my problem is that we've had, and you know, the legislative history has Assistant Solicitor General from the AG's office testifying, my gosh, we got all of these, we've got to get relief from this. But the legislature didn't respond like they did in other instances where the AG asked for relief with this pile of cases, such as the felony murder. They specifically said the amendments establish a procedural rule for the conduct of criminal prosecutions shall be construed and applied retroactively to all cases currently pending. The criminal history classification, my gosh, we've got to get that done because, you know, we've got all these cases in the pipeline. So are procedural in nature and shall be construed and applied retroactively. The hard 50, we had a special session of the legislature because, oh, we got all these murder cases. Shall be construed and applied retroactively. Establish a procedural rule shall be construed and applied retroactively. and they have this testimony that, oh my gosh, this is the same thing that we've had in these prior cases, we've got this pile, and they didn't do that. The legislature didn't do that. How do we take that as not a conscious decision by a legislature that knows how to kill all the cases in the pipeline by calling it calling it procedural and declaring that it's retroactive?
Well, I agree that maybe the legislator should have done that, but the analysis doesn't necessarily, it is something for you. Generally, it is, if there is no retroactivity language, it goes perspective. I agree with that, but it also, the case law talks about, but if it's a procedural matter, that it can be considered retroactive.
It can be, but our touchstone is legislative intent.
Well,
that's our overall first touchstone, is what's the legislative intent.
I would make the argument, looking at a change of law, is still reflecting back on what the change of law was in the past. So there is some legislative intent I think you can take from that. Obviously, it was a response to Dickey 1 and Dickey 2, and the fact that Apprendi was a part of that. So I think that it does refer to that. We're still arguing in our case that it be applied retroactive because it was a procedural and it did not affect it didn't have affect a substantial vested right. It does go back to Gould and Apprendi, and then those were such a momentum cases that's the reason why Mr. Dickey got to the argument that his sentence was illegal, and that was of such importance to that particular case, and importance that it doesn't necessarily apply to Mr. McAllister because he didn't have those arguments back then.
And you mentioned it didn't affect substantial right. You would agree that time in prison is a substantial right.
Well, correct.
And what you're saying is that when Dickey came about, I think the motion, I have written down here, the motion was filed May 20th, 2015, and Dickey 1 was May 22nd, 2015. I may have wrong dates, but anyway, that at that time his right was so speculative that the amendment didn't destroy it. Well, if under Dickey 1 and Dickey 2 he was entitled to have a reduction in sentence, then and then they passed the amendment to the statute, it didn't affect a substantial right, even though he'll spend less time in prison because it's speculative, because it hasn't been ordered, the reduction hadn't been ordered. Is that your argument?
Well, I think, well, Dawson talks, well, I still think it goes back to the Gould and Apprendi case. It always comes back to that. He didn't have a vested right with Apprendi. If Apprendi was to go forward and he was sentenced and final, he never had a legal right. He didn't have any vested right in regards to that.
But you're talking about, okay. You're saying what we're really talking about is he had no vested right in the Dickey opinions.
Or the
not in Apprendi.
Well, he didn't have any vested right that, well, he didn't have any vested right because, well, Dickey and Gould and Apprendi, they weren't, I don't think, respectfully were considered by this court. And if those cases were to be considered, and this court were to say yes, that those were important and they were to be prospective, and they don't apply to Mr. McAllister because prior his case was final, and that he doesn't get the same relief as Mr. Dickey because this particular case was so important for the decision to be made. Then he didn't have that. He didn't have a vested right. He doesn't have a right to figure out that the Gould case is going to be overruled or decided overturned in the future.
You're just saying that you think we have to go a layer deeper than Dickey, the two Dickey opinions themselves.
Yeah, I
what
think
Dickey was dependent upon, and because what it was dependent upon did not exist until after his convictions and sentences were final, he has no right to relief under Dickey.
Yes.
Okay, got you.
All right. Thank you, counsel.
Thank you.
Gerald E. Wells for Mr. McAllister. I think it might be appropriate at this point in time to reflect on what was said in Dickey 2. And the court said in that case, a defendant whose sentence is illegal based on the holding in State versus Dickey 2 is entitled to receive a corrected sentence at any time, even if the sentence became final prior to the decision in Apprendi versus New Jersey. I don't know how you can say that any better and mean it. I mean, after all, the whole retroactive issue, that ship has sailed. And it sailed with Dickey 2. So the argument that somehow this court should review again the Gould case and Apprendi and its effect is that's already been decided in Dickey 2. So that argument just is not going to be effective for the state in this case.
But Counselor, it is kind of counterintuitive. We've said that you can't alter the conviction based on Apprendi and his progeny, but you can alter the sentence.
You can alter the sentence because it's illegal and you need to correct it because the criminal history is not correct. Now, the state has adopted in its argument the dissenting opinion of Judge Gardner in this case, in Mr. McMaster's case. And I'm not certain I completely understand what the argument in the dissent was in respect.
Concurring.
But
It was a concurring opinion.
yes, but there was some language in there that indicated there needed to be some clarification because after all, Apprendi is the constitutional basis for the new statute. And I think this point is particularly important. There was also language in the state's opinion or brief that it would extend, Dickey 2 would extend the theory that should be an end to litigation, that it would be endless litigation if you allowed it to stand. And that simply isn't the case. In my experience, 3 decades of doing criminal litigation, I've never seen a case that was endless. I mean, there is an end. So I don't think that's a viable concern at this point. But in any event, the motion to correct an illegal sentence is based on a very narrow set of circumstances, which is covered in Mr. McMaster's case. And it was perfectly appropriate for the McMaster Court of Appeals decision to hold that Dickey 2 covered all those circumstances. And the state wants to keep arguing the effect of Gould when in effect Dickey 2 said that all of those differences, procedural differences, fade into irrelevance. And that's exactly what's happened here. Gould and arguing Apprendi in these circumstances simply will not win the day for the state because of Dickey 2. There's just no other way to say it other than what has been said in that decision and obviously followed by the Court of Appeals here. It's you simply have the circumstances here where this court held in Dickey 2 that Apprendi is not a deterrent to going back and even if the sentence in concern was before Apprendi. And they have every right, Mr. McMaster has every right to go back and have his illegal sentence corrected.
I'm probably confused, counsel, but I understood the state to argue that there was a factual distinction between your client and Dickey with respect to when their sentences became final. Am I,
Well,
Is that
that
wrong?
may be. I mean, I don't think so, but by way of what the motion to correct really means,
well, did one of their sentences become final before Apprendi and one after?
yes,
So Dickey's sentence became final after Apprendi.
yeah.
So,
In one case, it didn't make any difference. In the other two, it does. In the sentences. So I think it does apply, and that's what the Court of Appeals held. And I think that this court has the duty to remand it back to the district court in Finney County.
again, just for clarification, you quoted some of what I thought was our case law at the outset of your argument with respect to with respect to cases where sentences became final before Apprendi.
No, I didn't mean that. I
Okay.
misspoke.
Well, you may not have. I may have misheard. I was just going to
mean-
ask what that was.
Dickey 2 is clear and it's controlling in this case. And for all the reasons stated by the Court of Appeals.
But as a matter of fact, did Dickey 2 address this factual scenario where a defendant's sentence became final prior to the issuance of Apprendi? I guess that's my question.
I don't recall exactly.
It wouldn't have if the state is correct that Dickey's sentence only became final after Apprendi. We wouldn't have had this particular factual scenario in front of us.
I don't recall specifically. Unless there's any other questions, that's my argument.
Any more questions? Thank you, counsel.
Thank you.
May it please the court, I'm going to make it brief. I don't really have any other rebuttal. If you have any questions, that'd be fine. I think there is a big distinction, as I just want to reiterate that Apprendi was the precursor to why Mr. Dickey's sentence was declared illegal, and that's a huge factor in this. I don't think the court went far enough in terms of deciding it didn't have the same factual scenarios that Mr. McAllister does, and that I think this court needs to consider that and make a decision that since it was on collateral review prior to his sentence being final, prior to Apprendi being decided, that it should not, he should not be granted relief, and ask that the Court of Appeals decision be reversed.
But Dickey 2 was collateral review. Dickey 1 was a direct appeal, and
Yes,
kind
I'm
of
sorry.
the point of Dickey
Correct.
2 was, it also, because Dickey had several PVs, probation violations at the same time he was sentenced, and those came up for Dickey 2. We said, yeah, the Dickey 1 rule applies, right.
Yeah, I'm not disagreeing with that,
And so, but you're asking us to interpret the sentencing scheme or the statutory provisions relied upon in Dickey 2 differently because of the time.
yes,
Is it fair to summarize your argument as follows? Dickey 2 got relief because his sentence at the time it was pronounced was illegal, whereas McAllister doesn't get relief because at the time the sentence was pronounced on him, it was legal.
because Apprendi and Gould, yes.
All right. Thank you, counsel. Thank you both for your arguments this morning. Court will take this matter under advisement.